what he's seeking to achieve. Hello, good evening, sir. Welcome to Eyewitness News. The Chief Justice is being suspended following the founding of a prima facie case against her in that consultative process between the President and the Council of State. Is this application, what do you intend to achieve? That the Chief Justice will be recalled, or what exactly are you seeking to achieve?
Well, Solomon, I think right from the onset there's been procedural impropriety, and I sought to make sure that the process is not tainted with illegalities or procedural negativities. I say so because you remember I filed my first application at the Supreme Court asking for certain declarations, which declarations was swiftly followed with an application for interlocutory injunction. Because I believe that the President of the Republic of Ghana, first and foremost, should have given the petition against the CJ to respond, or if you like to give some comments, even before any consultations or whatsoever will be done with the Council of State. That did not happen. I think that the petition had been on the desk of the President for about 6 weeks until my application at the Supreme Court, which made the President now give the petition to the CJ. Now, my point is that whilst the application and the substantive matter itself is pending at the Supreme Court, it is my belief that until the determination of that application and that substantive matter, the President should not or could not have gone ahead to suspend the Chief Justice. Because for me, that matter is already before the Supreme Court. So why don't we allow the Supreme Court to hear the matter? Then after, if the President has anything to say or do, then he can go ahead. And so it's on that basis that I believe that what the President did or has done by suspending the Chief Justice is not in consonance with the law.
So that's the main ground for your application, that because the matter is pending before the court, the President didn't have to take any step that will prejudice the outcome of the case.
Absolutely.
But can anybody injunct the President from carrying out a constitutional duty, really?
Well, it's debatable. It is my belief that when there is a matter that is before the court, whether constitutional matters or even matters like these applications, my belief is that, especially if you want to take a cue from the Moffat case, even though it is a pending matter, it is supposed to be seen as an injunction in itself. And so matters, or if you like, the content of my release that I'm seeking from the court, it can fall anywhere. And so in the event that it falls where the President itself or the President himself is attempting to deal with the matter in such a manner that will prejudice the pending, or if you like, the instant case, I think that should not be the way to go. And so it is my belief that the President ought to have waited for the matter that is before the court to have been determined before any action or whatsoever would have been taken.
But what will be is, if this is allowed to stay, that anyone who feels or who thinks anyone with the right goes to the Supreme Court to injunct or to mount an action against the President or the discharge of a constitutional duty, don't you think that would draw the state back? Because the President has a lot of things to do by the Constitution, and anybody could go to court, raise an issue, and seek to injunct the process. If that is the case, nothing will happen. The president will be waiting for Supreme Court or the court forever, and they cannot work. That is why, you cannot injunct a president from carrying out a constitutional duty. Everybody can go to court and injunct or seek to injunct the president. If it is so, the state will grind to a halt, and that will be a difficulty, won't it?
Well, when the power is given to the president to, as it were, do anything constitutionally, it will have to be done justifiably, it will have to be done fairly. And so the fact that the power has been given to a president to act or do anything doesn't mean that it should be done anyhow. It should be done capriciously or whimsically. Now, I say this because even before the 2024 election, the president himself, and I say this by way of the president's intent, which is supported by his own party architecture, but the president's intent has been to take off, or if you like, to remove the president of the republic, the chief justice. If you look at the supplementary application that I filed on Tuesday, the supplementary application sought to indicate the intent of the President of the Republic of Ghana, which intent is not good for our democracy, because you cannot say before 2024 that is before 2024 general elections, that when given the opportunity, you are going to clean the judiciary from, quote and unquote, political animals. That is the act, in my estimation, that is what he is trying to do. We've had his own chairman of the NDC having cause to say that when given the opportunity, or in his estimation, the CJ and the Electoral Commission should be taken off. We've had people who are also appointees of the government at the presidency, Mustafa Gandhi and co., who sought to say that the CJ and the Electoral Commission should be taken off. And so the intent of the actions are also relevant. And so the fact that the power has been given doesn't mean that the power should be used in such a way that it will affect and assault our democracy. And that is why, as per the Constitution, that is Article 2, any citizen like myself has every responsibility to protect the Constitution of the Republic of Ghana. We are testing the law. I believe that the law is on my side. Let us wait for what the Supreme Court will say.
Yes, there are others who said that, who canvass your position as well, and even say, go to the extent of saying that the president might have acted contemptuously of the courts. Is that something you are looking at?
Well, I made a Facebook post on that, I think, on Monday, because at the time I had already suspected that His Excellency the President wanted to take this move. You see, if you're a lawyer, you have every responsibility to assume that position as an officer of the court. You have the responsibility to also advise your client. In this instance, the Attorney General is the lawyer of the President. He has every responsibility to advise the President to act in such a way that will be in consonance with the dictates of the Constitution of the Republic of Ghana. In the absence of that, the Code of Ethics that regulates we, the lawyers, it's clear that you can be sanctioned for that. And so if there is a matter that is before the court, which matter the AG, or if like the President, is a party to it, and as an officer of the court, you ought to advise your client not to do anything that will prejudice the content of the application of injunction that is before the Supreme Court. And so if the AG looks on, and you see, the actions and the inactions of the AG seems contradictory, because if you look at the application, if like the response to our application that was filed by the AG, he stated clearly that the President had no responsibility whatsoever to refer the matter to the CJ for comment or response. This is what the AG filed in court. Meanwhile, we had his client, that is the President of the Republic of Ghana, now giving the petition to the CJ to respond to it. What are they trying to communicate? What are they trying to say? So I'm just saying that in all of these things, there seems not to be a clear intent in acting on the procedures as has been enshrined in Article 146 of the 1990 Constitution is seen to have been orchestrated, is seen to be choreographed, is seen that someone is bent on removing the CJ. Yes, you can remove the CJ, but that is an assault to our democracy. Let it not be said that tomorrow any president will come, or if like every 4 years or 8 years, the head of the judiciary will be taken off. So, in removing the head of the judiciary, please, whatever accusations or whatsoever that is against the judiciary, head of the judiciary, should be deeply grave, should be serious. It should not be anything frivolous or vexatious. People who are watching, diplomatic community, well-meaning Ghanaians, have seen through the lines that this is just a political attack. It will not help our democracy. And I don't think that as a Ghanaian, as a citizen, as per Article 2 of the 1992 Constitution, I will sit aloof for this thing to go on. And I'm praying that the Supreme Court will see reason in the relief that I am seeking. If it doesn't, as the tortoise said in the Chinua Achebe's book, we will try and do whatever we want to do. But if it doesn't happen, we have done our best. But I believe that the Supreme Court will see reason in the reason why we've gone to court and agree with our relief that we are seeking.
A texter wants to find out what enforcement or interpretation issue is at stake. For which reason you are at the Supreme Court?
Well, with the interpretation issue, I felt that, you see, Article 146 does not clearly talk about the fact that the president will have to establish a prima facie case against the CJ. Of course, Ejechum came to, as it were, fill that gap. But the interpretation that I am seeking directly from the Supreme Court is that in terms of procedure, the president ought to give the petition to the CJ for response and comment even before any consultation whatsoever will be done with the Council of State. Other than that, we will be opening the floodgate for petitions, frivolous and unnecessary petitions, to be flooded at the gate of the president, and the president will also be sending, if you like, will be ferrying this or these petitions to the Council of State. The President of the Republic ought to establish a prima facie case after he has received the petition, which petition should be ferried to the CJ for the CJ to give comments and responses before that prima facie will have to be established. This has not been clearly stated in the Constitution of the Republic of Ghana. And so it is my belief that upon reading in its entirety and bringing about the letter and the context of the 1992 Constitution, as it is demanded upon us by the Interpretation Act of Ghana, and that in interpreting the Constitution, you have to do so purposively, that upon a true and proper interpretation of Article 146, the President ought to give the petition to the CJ before any consultation will have to be triggered or otherwise. And that is the crux of my declarations that I am seeking from the Supreme Court by way of interpretation.
I see. But one would expect that, I mean, the matters you are raising fall squarely within the rules of natural justice. So that was done, and that is it. So many do not really see the issue of interpretation there, because it's implied, it goes without saying, that you don't condemn a man, or in this case a woman, until after you have heard him or her. So, and that has been done. That essentially makes your application or makes your suit moot. Don't you agree?
The doctrine of mootness does not apply to constitutional matters. And the fact that there has been an acquiescence, it cannot be a defense for me as a citizen of the Republic of Ghana to protect the Constitution of Ghana. When you look at the recent case of Kwame Bafo, that is Abronye, and the Attorney General, the Supreme Court had the occasion to reiterate the point that was made in the J.H. Mensah case. That unless, of course, a matter does not lend itself to reoccurrence in future, unless, of course, it does not lend itself to any reoccurrence, then the Supreme Court will not bother with matters that has already been determined. If
Very well.
that is anything to do that.
Very
but
well.
if there is a potentiality that the matter will reoccur, the Supreme Court has every responsibility to make sure that it will determine the matter to forestall future reoccurrence. However,
well, very well. Thanks, Vincent Assafuah, applicant in that matter and member of Parliament for the